All right, sir, this is on your motion. Is there anything that you wish to say?
Just that what I sent in, he's been with me since March 9th. And yeah, he's been living here full time. Just everything I wrote down.
And Ms. Ford, is there anything you wish to say?
Yes, I'm actually trying to find, well, I have a lawyer, but I don't have a meeting until October 25th. So I was hoping to get some legal advice and representation before we went any further.
When is that, October 25th?
Yes, it's as soon as I can get in with anybody in town.
Okay, so what I'm going to do at this point is this. I am going to find adequate cause. And Mr. Barker, I've got that order. I don't have any proposed order from you as regards placement, parenting plan, or child support. I am going to, at this point, given the age of the child, visitation with Ms. Ford is going to be as agreed between the child and Ms. Ford. And I'll defer on the issue of child support so that when this is next heard, the child support can be retroactive back to this date. Do you both understand that?
Mm-hmm.
And let's see, so October 25th, you said, is your meeting?
Yes.
So let's set this to November 2 at 9 o'clock.
Okay.
Okay.
Did that cover everything from your standpoint, Mr. Barker?
Yeah, yeah.
And from your standpoint, ma'am?
Yes.
All right, I will sign this order. So, ma'am, I put this over today to confirm that you had signed up for the Family Wizard. Has that happened?
Yes, it has.
And can you confirm that, Mr. Sorensen?
Yes, she signed up for it on Tuesday.
All right, thank you. So, ma'am, I want to make sure you understand if there are violations of the order down the road, it's going to cost you money or worse. So those orders are not suggestions. You understand that?
Yes, I do.
Okay, then we will leave it there.
Yes, Your Honor, I'm here.
I'm here.
And Ann Height, guardian ad litem, Your Honor.
And we are on for a review hearing. Got a proposed parenting plan. And Mr. Lovato, have you reviewed that proposed plan?
No, Your Honor, I haven't received it yet.
Okay. And Ms. Height, have you been able to meet with the parties?
I have been able to meet with them. Mr. Lovato is in Alabama, and so I have met with him on the phone, and I've met with Ms. Watts here, or I'm sorry, Hastings here in town. I haven't seen a parenting plan, Your Honor. They're still working through, I believe, some of the issues.
Okay, so ma'am, the proposed parenting plan that you've got doesn't say a whole lot. And Mr. Lovato is going to have to review that as well. So make sure he gets a copy. And if the two of you can work out your differences, that would be great. But I need to have a parenting plan that either you both signed off on or one that reflects what the judge ruled previously. You understand that?
Yeah, I just wasn't sure about filling out the parenting plan and because I couldn't remember exactly what the judge had said. I wrote down that she had said that I think she said from Christmas, the first week, until Christmas Day. And then I think, like, I don't remember the time that she said for Brandon to pick them up on Christmas Day. So I was hoping that I could maybe get a printout of exactly what she said so I could just copy word for word what she said.
If you contact the clerk's office, they can forward to you the minute entries from the judge's decision, so that would make it easier for you.
Oh, okay.
All right.
Your Honor, might I ask your indulgence for one matter?
Yes, ma'am.
It's come to my attention that these parents, the kids are back east and the parents are separated by a long distance. And a lot of the information between them has been awkward. And it appears that the kids are being drawn into some of the discussions. And I wonder if Your Honor could remind the parents, both of them, that the kids should not be placed in the middle of adult conversations or asked either to send messages or to keep secrets from either parent. They have enough stress in their life without anything extra. And I wonder if Your Honor could just address that this morning for the record.
Well, I did note in the judge's decision from the last hearing, the children aren't to choose, the children aren't to be consulted about the parenting plan. Folks, so you are aware, there are dozens, if not hundreds of studies out there that say the very best way for you to screw your kids up for a very long time is to put them in the middle of this. And that includes telling your kids what a jerk the other parent is, telling them that they have some, they get to choose who they go see because they're over 12. That's a real popular one. The kids are not part of this discussion. I don't care how much you two are at odds with each other. As I say, if you are really intent on doing serious long-term damage to your kids, that's exactly the way to do it. Do you understand what I'm saying?
Completely,
Yes.
Your Honor.
Okay. And I know it is tough. These are really emotional situations. But you guys are going to have to be, the adults in the room and just make sure, as far as the kids are concerned, that mom and dad are having difficulties, but it's nothing to do with you guys, and you're just going to live your lives. Okay?
Yes, Your Honor.
Please do so.
Thank you, Your Honor. I appreciate that.
Thank you. Mr. Slott, have you done the UA and hair test?
No, I don't know.
And Ms. Slott, have you done the UA and hair test?
No, because I didn't know there was one that needed to be done.
Well, now you both know, and that order was from June, so it makes you both look pretty bad. So you need to go get that done immediately.
No, we already did those ones.
Mr. Slott just said you hadn't, and you just told me you hadn't, and we don't have proof of any of them. So, Ms. Height, are you there available?
Your Honor, I was, both of these parties were very difficult to reach, and I was actually dismissed from the case December of 22. So I would need to be reappointed if there's going to be more activity. At one point, both parties and both of their new partners were all living together and kind of sharing the care of their daughter, which for a lot of reasons didn't work out, apparently. And so there was no action being taken. I had no response, no payment, no contact to speak of. And so the court dismissed me December of 22.
Okay, so with that background, Mr. Slott, what do you want to tell me?
With them living.
And would you either turn off the TV or tell the people in the background to quit talking?
Sorry. If for a lot of reasons, it wasn't working out when we were living together. I'm currently living with my parents, but me and Cheyenne came to an agreement with the parenting plan, and we have signed the divorce papers, and we have a new parenting plan. I just haven't put it in the court system yet because I was waiting for the court date.
And Ms. Slott, is that accurate?
Yes, that is.
All right, I'm going to strike today's hearing.
Your Honor. This is Casey Looney with the state on behalf of child support. The state has not been served with any paperwork. We are involved because this child is on TANF. So if the parents are coming to a new agreement, we do need to be served that paperwork. We need to sign off on a child support order.
All right. Did you both hear that?
Yes, we did.
So you both need to contact the prosecutor's office immediately.
Okay.
All right. You can put it back on when it's ready.
For a restraining order represents Mr. Nicholas Davis. I do believe Holly Davis is here on Zoom. There is a temporary order in place. I received word yesterday from my client the parties may have reached a resolution on their dissolution. And I'm just asking that it be set over, that the temporary order remain. I think now that there's an attorney involved, it should probably go on the attorney docket. That would be the 10th if it's available, or the 17th. And hopefully we'll be able to enter final orders by agreement. Ms. Davis, does it sound right that the two of you have reached a resolution?
As far as our divorce, yes.
Yes. Okay.
Okay, that sounds like there's a qualifier there, Ms. Davis. Is there an issue that we need to address?
Well, with the restraining order.
I guess my thought is with the divorce, the restraining order may resolve. The word came in late yesterday after I was out of the office. Ms. Davis didn't file any responsive declarations or pleadings that I can see in the file, nor was I served with any. So I don't know if she has any material before the court to be considered today.
Yeah, when I looked at the file, the restraining order basically didn't have anything to support it, and there's no response. So I can't do very much on that today, Ms. Davis. I suggest you contact Mr. Baldwin's office, and you can get that taken care of as soon as possible. It sounds like by agreement. You understand that?
Yep.
All right. Thank you, ma'am.
So can we send it over to the attorney docket, Your Honor? It would be appropriate on the 17th and extend the emergency so that we can get it resolved.
October 17th. And what time is that docket? One o'clock. Okay. You get that, Ms. Davis?
Yes.
All right. Thank you. Jeffrey Bierbauer and Ashley Bierbauer.
Good morning, Your Honor. Michael Reed appearing for Ashley Bierbauer.
Amy Powers for the state of Washington.
And Ann Height, guardian ad litem, Your Honor.
And do we have Mr. Bierbauer?
Good morning, Your Honor.
All right. I have a proposed parenting plan order. Mr. Bierbauer, you seen that?
Yes, I have. I got it at 10:30, and I wasn't able to review it till I got home last night after work, and after I took care of my kids.
So does it look like it accurately reflects what the ruling was?
There's a few things that I would like changed.
Okay, that's not my question. So listen carefully to my question. Does the order accurately reflect what the court ruled?
Yes.
Okay. And Ms. Height, from your standpoint, is that true?
Yes, Your Honor.
Okay, so Mr. Bierbauer, if there's some things you want changed, you need to bring a motion. The issue today is just presentation. Is this order reflective of what was decided?
Okay.
I've also reviewed it, and there is a sentence in there about child support, which is appropriate.
All right. Thank you, ma'am.
Which I bring that was actually taken out of my check again.
I will contact the support enforcement officer again. I gave them notice, but now they've been waiting for the signed order. I'll make sure they get a copy of that.
Thank you, Ms. Powers.
Yes, I'm here.
Yeah.
All right. Thank you all.
Thank you, Your Honor.
Your Honor, Amanda Holder representing Mr. Kozad.
Ms. McGregor, this is your motion. Anything you want to say about it?
No, I think I have everything that I needed to say in the papers.
Ms. Holder? Oh, you're on mute, ma'am.
I'm sorry, Your Honor. I would request that this case be set over as service was not done in this matter. And so we would like to request a set over at the court's convenience.
Okay. So, Ms. McGregor, we don't have any service on Mr. Kozad, number one. Number two, there are some other issues with this that are going to have to be sorted out. But I can't proceed today because Mr. Kozad hasn't been served.
He has been served. That happened. I have the papers right here for it.
Okay, well, you having them doesn't help me. They need to be filed with the court.
They were filed.
They haven't made it to the court file if that happened. So 2 weeks, counsel, that work?
Yes, Your Honor.
And that work for you, Ms. McGregor?
Yep. Yes.
Okay, and if you have that proof of service, you need to get that filed right away.
Yeah.
Okay.
It was already filed, but okay, thank you.
You might check and make sure that.
Yeah, I will.
Thank you, Your Honor.
Yes, Your Honor. I'm Anne Marie Stormo, the Guardian. Can you hear me?
Yes.
Oh, I'm sorry. I'd like to ask for another continuance. Deanna has decided she didn't like my rules and has left my house. And she doesn't want to live with her mom either. So I'm not exactly sure what I need to do with this.
Where is the child now?
She's staying at a friend's house. And she refuses to go to either one of our houses.
And have the police been called?
It hasn't been 48 hours or 24 hours. My cousin is a police officer here in Longview, and so I've talked to him. He said after 24 hours, call it in.
All right, I'll continue this one more week.
Okay.
Ma'am, in the meantime, we've got the original letters of guardianship unfortunately didn't indicate a termination date. So they're basically only good for a year in that circumstance. You need right away to get a motion in to extend those. So if that's where we end up, that's what we can do. You understand that?
Yes, sir.
All right. I will move this over to, is that the 4th? The 5th at 10:30.
And I'm here as well, Your Honor. Tina Day, Guardian ad litem.
Has a full guardianship petition been filed in this case yet? Ms. Day, if you know.
No. I don't believe it has been. I know the petitioner's been working on it. And then I also wanted to update the court that I was able to make contact with the institution where father is being held, and they've agreed today to accept service via email and provide proof of service to him for both the minor guardianship and the full guardianship. So if we could have possibly 2 weeks, I think we can work together with the petitioner and get that accomplished.
The current order expires the first part of, I think it's November 2nd. So would it make sense to put this to October 31?
I think that would be fine.
All right, I will do that. October 31, 10:30.
Okay, thank you, Your Honor.
Morning, Your Honor. Donald Esau here for the father, David Birch, who is also present on the Zoom.
Good afternoon, Your Honor. Josh Goodday here for Miss Moxley.
And Ms. Winkles represents the child?
I do, Your Honor.
And I'm here as well, Your Honor, the Guardian ad litem.
All right, Ms. Day, let me start with you just to get an update. Where are we?
Well, where we are is with a lot of confusion. I filed my report, and I think everybody is in agreement and understanding that the current emergency guardian is absolutely not acceptable, and the child has to be placed in a subsequent location. Mother had updated me yesterday that she had filed another petition for placement with a maternal aunt who resides in Salem. I've had a cursory look at that, and I don't find any objection to that. I don't believe the child is in agreement with going to that placement. The other relative that was promoted and a friend of a family member, or a friend of the child's friend, the parent of a child's friend, also is not appropriate. So we are in a situation where the child either has to be returned, which I don't think anybody is in agreement with, or she's going to have to go with the subsequent guardian who's been promoted, which is the maternal aunt, Brianne McCabe, and her family, who reside in Salem, at least on an interim basis while that can be investigated.
Teresa.
Your Honor, my client would prefer that the child come back with him. He's taken care of her for the last 7 years. It doesn't believe some of the allegations that have been made. He's been assessed for a drug or alcohol assessment and is willing to follow through with the treatment plan, which he's pretty close to no specific problem, but there's enough of an issue there that he needs to take care of that. If the court is not willing to place her with him, then he would support the aunt as a family member that Daylin knows to be the emergency guardian at this point.
And is that the aunt in Salem, just to be clear?
Yes, the aunt in Salem.
All right.
I thought there was an aunt in Boise, but I didn't hear anything about that.
There is an aunt in Boise, but her and her husband did not pass the necessary requirements.
Oh, okay. Thank you.
And Mr. Goodday?
Your Honor, my client, I believe, is the same position, that I think she'd be okay with it going to the father. And if that's not acceptable to the court, then she'd like her sister, Miss McCabe, to be appointed guardian.
All right. And Ms. Winkles, who I barely recognize.
Yeah, that's because I'm on my home computer camera trying to, I have no idea what's going on here. It's a camera that happens to be here that I've never used. So my client is very concerned. The first thing is that she does want to go back with dad, but she wants to go back with dad only if he moves out of his current residence. She is, when she found out he had received the SEDS evaluation and that he was going through a treatment, that's where she wants to go, but not in his current living situation. The grandmother, my client, the grandmother is an issue. And the grandmother is the precursor to what led to all of these fights. And it got physical. My client, if dad were to move out tomorrow to another location, my client would want to be with him immediately. My client doesn't have anything against Brianna, but my client is currently at MacArthur in Vancouver, is on the volleyball team, had a volleyball game last night. And she's really into that. And for the first time in her life, she's really caring about school and extracurricular activities. Her fear is that she's going to have to move somewhere. Salem's quite far away. And then when dad does move out and goes through, a month of treatment or whatever, that she's going to want to come back with dad. So that's her main concern. She does put up another person, which I only found out this yesterday because it was a 2-day essentially extension here. There is a woman named Michelle Broomholtz, I believe is her last name. She is a CASA worker and has been for about 10 years. She's an older lady. She has no relationship to anybody here. She's literally just somebody who takes on foster kids. My client met with her yesterday. She lives alone. No drug history, no criminal history or anything like that. She wanted to see if that would be okay, but we would need time to investigate who that person is. And that's in Longview. And that would just be until dad found a place outside of, currently lives with his parents. It would just be until dad moved out from the parents, and then my client would want to go with him immediately.
Does that solve the issue of her wanting to continue at MacArthur?
No, but at least it keeps it the same school that she was at.
Ms. Day, you know anything about that individual?
No, this is the first I'm hearing of that individual. Okay. I'm certainly willing to look into that, but we have to make a decision, I think, in the interim. She cannot stay with the individual she's with. There was another incident that occurred yesterday involving contact with an individual who's very well known to the court for his criminal history, and a police report was filed based on that contact with this child. And it just we have to get this child in a safe place. Jeremy Royal, that's the individual, sorry.
Okay.
And most
so
people
here's my problem. We're operating under a petition for a minor guardianship. It's basically got nothing to do with any parenting plan between the two parents. If I deny the petition, which certainly at some point I need to, because of the impropriety of the petitioner, that leaves the child completely in limbo.
And
Your Honor,
my client just responded saying, and remember she's 12, so bear with me. I'm not going with him until he does treatment. He knows why.
Well,
so I would ask for Brianna at that point.
I understand.
Your Honor, may I say something? I filed Brianna's petition for the emergency minor guardianship this morning because I was told that my other sister was not able to. So there is a petition that I filed with all of her confidential information, everything that is needed from the court in order to push that through today. I am very concerned as Kristen Kearney has left my daughter in the presence of somebody who made a derogatory sexual invitation towards my daughter in the past, and Kristen is aware of this, and left her in the presence of this man alone. And so I filed a police report with the sheriff's department yesterday. I am very concerned that Kristen is not able to provide for my daughter, and if we can at least place her with Brianna until you guys have further investigated every other avenue that you guys feel is necessary in order to place her, like, I would be extremely appreciative of that. I feel it's extremely necessary that Brianna is willing and able to pick her up today. They both work for the government. Brianna works for the state government and her husband works for the federal government. They've never had any criminal history. It's a very safe environment for her to be in.
And Your Honor, I'm doing real time. Remember, my client is in school right now. So she says that Brianna will just give me immediately back to my mom, and there's a restraining order that my mom is kind of the controlling one in all of her relationships with her siblings. In that case, I would rather go to my dad, even though I believe it's like handing a gun to a toddler. But if my dad can be made aware that there is a restraining order against my mom, and that he doesn't violate that in any way, then I'd prefer to go home with my dad, because I do believe it's safer and it's closer to the court and to Longview.
It's crazy.
My name is Brianna. I'm aware of the restraining order between Dalen and her mom, and we are willing and able to respect that until something changes with the court. Dalen doesn't need to see her mom if she doesn't wish to at this time.
Miss Day? Okay, here's what I'm thinking, because I don't have any good option in this proceeding. I want to continue this matter for 1 week, and Miss Day, can you ride herd on this? And if there's an emergency, I will hear it again on no notice to anybody.
Your Honor, I have a question, and I would never normally put anybody up for this, but I'm very worried about this 12-year-old.
I am too. Hang on just a second. I'll get back to you. Ms. Day, are you in a position to look immediately at the proposed person, look immediately at Brianna, and see if they're actually going to do what I tell them, those kind of things?
Yes, Your Honor, I could do that today. I could have that done today.
And Your Honor, I would never normally do this, but I'm incredibly worried about a 12-year-old. I don't know if this would be a violation or a conflict or anything, but I have an 8-year-old. I have an extra room. I am a single woman. If this gets really bad, I live in Longview, the child can stay at my house for a period of a week until, I just don't want this child running away, being in foster care. I don't know what to do here as a lawyer. I also have a bedroom at my office because I sleep there sometimes when I'm working late. I know that sounds horrible. I just want to protect this child in any way. If the court can give me some instructions on what to do, my fear is I'm going to get a call at 1 a.m. in the morning from the child, and then she's going to be on the street somewhere.
Yeah, I appreciate the offer. I also, I'm immediately concerned for you and your professional situation with that, and I understand you are too. Okay, here's what I'm going to do. I am going to continue this guardianship for 1 week. In the meantime, I'm going to order Miss Day to make whatever investigation she can in as short a period as she can. I'm going to order that Miss Day then contact me directly. And based on that, I'm going to make an order about where the child is going to stay until next week. I don't know where that leaves us for next week. I share Ms. Winkle's concerns. Maybe we'll have the new guardianship petition to look at. And I understand the issue that creates with notice to parties. I just don't have any other option that I see going forward. Mr. Esau, anything you want to add?
Oh, you're on mute.
I share the concerns of the court as well. I'm sure my client does as well. So no concerns at this time.
Okay, and Ms. Winkles, if you can just emphasize to your client that the last thing we want is for her to be in a location where she's not safe or doesn't think she's safe, and we're going to do everything we can to avoid that, given the options we do or don't have.
Okay.
So we'll, as soon as Ms. Day contacts me, we will get an order out and go from there. Ms. Day, have you got my cell number?
No, Your Honor. Do you want to put that in the chat to me directly, or I'll contact the court and get that?
If you'll contact court administration and get it, I don't care what time of day it is. If you've got something sorted, call me.
I will do that. Thank you, Your Honor.
And I will give Ms. Day the name of this CASA worker.
Thank you, Ms. Winkles.
No problem.
Okay. And so then we're over till 10:30 next week. Where we will be at that point, we'll know then.
That's currently set as well.
Okay.
We've got a hearing set for the 3rd.
Correct.
And that's I don't know if I'm handling that. No, I'm not handling that calendar. So no, we'll just make it for the 5th.
Okay.
All right. Thank you all.
Thank you.
Judge,
Thank
can I
you.
say something?
Yes, sir.
My client wanted me to ask about visitation. I know there's an order currently in place, but would Ms. Moxley be able to have any kind of phone visitation?
My client would like absolutely no visitation.
Yeah, I think I want to kick that a week because I don't know what's going to set fire to the keg of dynamite at this point.
So the idea, though, is that you'll have an answer hopefully by the end of the day once you speak with Ms. Day for where.
Yeah, I sure hope so. But right now, I'm not going to order any visitation between now and next Thursday.
Okay. Thank you, Judge.
And Your Honor, if Mr. Esau can, I'm not sure if my client is the one hampering thing if he's in treatment is just the location where he lives. I'm not sure if Mr. Esau can talk to him about that. I believe Jason Lamb has apartments available. There are 2 locations in Longview that have apartments open now with 2 bedrooms that are very inexpensive. And she just we looked at those together. So she wanted me to stress that.
All right. I thank you for that. And I'll consult with my client and get back to you.
All right. Thank you.
Thank you all.
Thank you, Judge. Don Esau, Your Honor, for Ms. Murphy, Shannon Murphy, who's also present on the Zoom.
Kurt Agnostu for the father, Jeremy Murphy.
Aaron Winkles for the children, Chloe, and specifically Kristen.
And do we have Ms. Harrington? Yes. Looks like.
And Ms. Farr.
And Your Honor, Sherry Farr, I guess I'm kind of in between court visitor and guardian ad litem at this point.
All right, Ms. Farr, where are we?
So, Your Honor, I'll start with some compliance issues. On September 20th, I requested that mother sign an ROI so that I could get copies of her evaluation, her mental health evaluation, her substance abuse evaluation. And I have not received that signed ROI back yet. Your Honor directed that the parties were to complete a hair follicle before today's hearing. The petitioner is the only one who has done that, although her results are not due back until tomorrow. The father has not responded to me. I mean, we had one phone call. We've set up 2 interviews now, and he was no-show for both of those interviews. One of them was yesterday. So those are some compliance issues. The second issue is the younger child, Chloe. She is going to be 11 here shortly in a couple weeks, and she is requesting that she be appointed an attorney as well. I don't know if Your Honor is willing to do that because the age is 12, but I have seen the court do that for an 11-year-old. The next issue is that the court left it at my discretion to put visitation in place. And mother requested a phone call with Chloe, which I declined to allow because she had not complied with the hair follicle test yet. Also, Chloe has been very clear she doesn't want to speak with her mother. The reason for that is that she says that her mother will just put a lot of pressure on her. And she said if she has to talk with her, she will for one phone call, but she really doesn't want to. The request I had from mother was because she wanted to ask her directly whether she wants to come home or stay in Longview. So, you know, Chloe's reservation about having pressure put on her probably is pretty valid. I have interviewed everybody in this case at least twice, except for the father. There's been a lot of allegations back and forth. And I think that the court should note that the father's declarations are pretty strong, that saying that the mother has substance abuse. Her own mother says she has substance abuse issues. Father is saying that mother should not have the children. Father is requesting he has the children, but he hasn't complied with anything either. Mother says father has been abusive to her, but not to the children. Because my concern is that she doesn't recognize that the abusive environment that the children are in, even if the abuse is not on them, is still domestic violence. So father is disabled on disability right now, living with his father. I have interviewed the petitioner and her partner and the children privately and separately. And I believe that the children are perfectly safe where they are at. They're being fed, they're clothed, they're going to school. Those are all issues that both children have told me that were not fulfilled with living with their mother, that they went hungry, that they didn't have enough clothes to wear. And we know for a fact that the children are behind in their education and missed a lot of school. I believe that we should be putting the emergency guardianship in place. The children need dental work. We have some dental records showing that the father took at least Chloe to the dentist about a year ago, and she had 3 cavities then that needed work, and they still haven't been, she still hasn't received that work on her teeth. And now the older child also has a chipped tooth and some cavities. They both need dental work, and the petitioners can't do that without the emergency guardianship order. Mother has said that she is willing to sign her rights over on the older child, that she doesn't want to pay support for the older child, that she doesn't want to pay for dental care for the older child, that if the older child doesn't want to come home, she's basically has to take care of herself. The child is 16 and a half. She's still a child. She still needs support from her parents. Just because there's issues and the child doesn't feel safe or cared for at home doesn't mean she should have her medical and dental needs neglected. So those are my concerns. My recommendation is to put the emergency guardianship in place at this time. naming Gianni Harrington as the guardian. And then we go forward on the standard petition investigation.
Mr. Anagnostou?
Yes, Your Honor. As indicated in my client's declaration, he objects to the emergency guardianship and is requesting the return of his children. Now, in their response, they indicated that Haley may be petitioning for emancipation, and I'm looking at that statute. There's a form that if you're over 16, you can fill that out and go to court and become emancipated. But right now, what you have is a 16-year-old being parented by a 22-year-old, and my client, the father, is saying this is not good. Now, one of the questions I would have is, as indicated by Ms. Farr or by counsel Ms. Winkles, is that her client apparently took a hair follicle test, but you ordered all adults in a household, all adults. So her significant other apparently has not taken a hair follicle test. And you have before you a declaration from the cousin that lived in the household for a period of time saying that this other adult in the household is out of control, has mental health issues, is doing drugs, and you ordered a hair follicle test, and apparently he's not going to take one. And so, my client is living with his father. He and his wife are in the middle of a divorce. As part of that divorce, they sold the house, and the children are not homeless. There's room in the grandfather's house, my client's father's house, and they live in Skamania County. And they, this action, I mean, it shouldn't even be in this county. I mean, the children, their school is there, all their friends and family and doctors and everybody is in Carson, Washington, not here. And so my client is asking that the children be returned and that there's no basis for this emergency other than you have a 16-year-old who wants to run off with a 22-year-old and do whatever she wants.
And Your Honor,
I'm sorry, if I may just interject one thing. So the partner, Rain, absolutely will do a hair follicle test. The issue is that this couple could not afford 2 tests this week. They're struggling financially. They're getting no support from either parent to help with these children. The hair follicle test cost Miss Harrington $125. They didn't have another $125 to do the second test, but they're trying to get the money together to do that.
All right. Mr. Esau?
Yes, good morning, Your Honor. My client is the mother, Shannon Murphy. She's arguing for Chloe to come home with her. Her position is that Haley has specifically made it known to everyone that she doesn't want to come home. There may not be enough room. I don't know. It's a 32-foot trailer that my client is living in. She's the only one that's employed. And this is all in the context of a divorce. So it seems to me that on behalf of my client, that the girls are reacting to the split up between the mother and the father. They're taking it out on the mother and the father by bringing this action because they want to do, they probably, don't feel like they're a part of the family right now based on whatever's happened. Mother has always provided for the kids. There was a period of time, several months, when she wasn't working and she couldn't fix the tooth that everybody's talking about that needs fixed for Haley. But she's always fed, clothed, made sure they got to school, done everything that she's supposed to do. She does attend counseling once a week. She does attend AA meetings or NA meetings, 12-step group anyway. And she's willing to do whatever's necessary to get Chloe back in her household, where as 10 or almost 11, she needs the guidance of a mother who has 25 years experience. She's already raised 2 boys. Devin is one of the affidavits that was filed in the case. and she's been a mother for 25 years. There's experience there, which Gianna does not have. And I agree with Mr. Ignastu that that's going to be a problem situation if the 16-year-old and soon to be 11-year-old are going to be parented by a 22-year-old. They just don't have the life experience and the know-how to set boundaries. And we don't have any evidence of her being able to set boundaries either with these children. So we're asking the court, my client is asking the court to put Chloe with her. Haley can stay with Miss Harrington, and they get on with their lives at this point and get the treatment that they need and get through the divorce, because I think that's the real issue of why this is all happening. And it's certainly the context for lack of money, lack of emotional support, neglect. Not that it's excusable, but it's a difficult situation for all of them. And this is the first time that all of them have been through it. They're all hurting people right now, and they need to support each other and get back together to do that. Thank you, Your Honor.
Ms. Winkles?
Yes, Your Honor. My client paints a completely different picture. So Aaron Winkles on behalf of Haley Murphy, it's the name wrong the first time.
Let me interrupt. Is there any reason that I should not appoint you to represent both children?
As long as both children are aligned in what they want, I have no problem with that. If they aren't aligned, obviously it would become a conflict. I've only spoken to Chloe briefly, given that her age and that I represent her sister. Sherry Farr would know more about that than I do. If she's aligned, I have no problem representing her. It would actually help, because then I could put in her declarations, her words to the court, which I haven't been able to do yet.
All right, I will appoint you to represent both children. If it appears to you that there is a conflict in that, then you can advise the court.
Okay, absolutely.
All right, go ahead.
Your Honor, just before we leave that, I just want to raise an objection to the same counsel being appointed to both children.
I understand, and the mother's position makes that somewhat difficult, but I think it's the best thing we can do, and I'm not, given the impropriety of the mother's position, I guess I think that I don't need to spend a lot of time being concerned with that.
And Your Honor, when I meet the child, I meet with them individually with nobody else in the room. When I do that, I'll find out if there's a conflict. If there's a conflict, I'll let the court know, Mr. Agnostu and everybody else know immediately that it needs to be somebody else.
All right, go ahead.
What I'm hearing is a completely different history. My client states that the issues began long before they were separated. There was significant domestic violence within the house. Both parents have substance abuse issues. Dad is an alcoholic. They mentioned the type of alcohol he prefers to drink. Mom has a problem with methamphetamine. It appears Dad stopped drinking and took up methamphetamine, according to my clients. There was physical abuse in front of them. There was a lot of everything in front of them. They lost their house. They ended up short selling it. They move out. They live with Dad for a while. They claim that was absolutely horrific. Dad was verbally abusive, not physically abusive. They are afraid of Dad. Mom, on the other hand, is neglectful. These two children could barely read. The soon-to-be 11-year-old, her language skills when she moved in with the guardian was pretty much that of a kindergartner. That is pure and utter neglect. Literacy today is higher than it's ever been. The fact that we have an almost 10-year-old that is illiterate is a huge problem. Her math skills are similar. These two have no developmental disabilities. So the fact that both of them read at an age that is 5 years below them is a problem. Their school was not prioritized, neither was their health care. These two need such fundamental dental care that it's going to be a process over months. They essentially have more cavities and more teeth that need to be pulled out than most adults that haven't seen a dentist in a long time. It might also be that the young one has untreated scoliosis that, these are when children are growing, should have been addressed a long time ago. My client is the oldest one. She only did the emancipation application because her mom said that the mom let Gianna Harrington take the children and then claimed that she was going to call the cops on them That's why they were doing the emancipation. My client doesn't meet the statute for emancipation. She cannot support herself. She's 16. She's in school. She doesn't have a job. She can't drive herself. She's reliant on adults. So we look at this 22-year-old and immediately her age sticks out. And that's really the only thing that sticks out. When you talk to both the two kids and to Gianna, you get the picture of people that have lived through a lot and are much older than they really are. Gianna's parents, she did live with the natural parents in this case briefly in high school to graduate because her own mother is a massive drug addict. So you have a family of drug addicts, and then you have Gianna, who is not. She took her hair follicle. She will pass. They don't have a lot of money. They have rent. They have car payments. She did submit those to me because I stated that she needed to get them. I did contact her and state, my client says you haven't taken this. Why haven't you taken this? If somebody else will pay for it, if we can get county to pay for it, Taylor will take it as soon as possible. He has no issues with it. It's just the funds. $125 to some of us is not much. To people that are $10 here and there are no child support, no spousal. My clients state that if returned to dad, that one of them stated that she would just leave. They're afraid of their father. They're afraid of he doesn't hit them, but he body bumps them and he does other emotionally abusive things, which still fall under domestic violence, but would never leave a mark. Mother texts the children, even to this day, talking about how dare they do this when they know she was getting government welfare for them even after they left. And my client is very upset with mom because the last text exchange between them was essentially all about child support and all about funds from the government and fraud charges, and was nothing about the needs, health, wants, or anything of my client. These two girls are doing really well right now. When I saw them, they were both clean, well dressed. They're both in school. They're both doing well. Their reading scores from the time they've been in to now, which is a very short amount of time, have already leapt by almost 1 grade. So they are making significant progress. So when we look at this 22-year-old, well, 22 may not have the life experiences of, say, a 34-year-old. The fact is maybe that's not such a bad thing, because maybe some of those life experiences didn't need to happen. And unfortunately, my clients won't be safe. Mom lives in a trailer that is not hooked up to utilities. They live in a trailer with her boyfriend, who is not related to them. And they don't want to do that. They say he hasn't done anything, but they definitely don't feel comfortable all being in one room with some guy. Dad, on the other hand, lives with his father, who's a nice grandpa, but has no power. And dad is emotionally and verbally abusive, and they're not ready for that. They asked to remain where they are. In the interim, we can do more reports. We can see, and if the county can come up with $125 for that drug test for Taylor, he will take it. After that, I'm not sure what the issue would be. And so they do ask to remain where they are. They're very, very happy.
And Ms. Harrington, is there anything you wish to say?
No, Your Honor.
All right. I'm going to maintain the guardianship. At this point, the information I've got on the parents is very concerning. The children obviously haven't lived with the parents for some period of time, and the parents did not bring that matter forward. It was only when Ms. Harrington did that they want the kids back. We obviously don't have the hair test from them, nor the release of information from the mother. So given all that, I think the best thing I can do is maintain the guardianship with Ms. Harrington. Both parents are to get those hair tests done immediately. The county will pay for the hair test for Ms. Harrington's partner. The mother is to immediately terminate any government benefits that she may be receiving based on the children, so that there's no impediment to Ms. Harrington seeking those benefits. We need a date, 60 days out.
Just to clarify, you're going to be signing the emergency?
Yes.
Okay.
And Ms. Farr, I don't know that it's actually been said before you are appointed as GAL if it hasn't been said.
So, Your Honor, do you have the order there in front of you to sign appointing me?
No, I don't.
Okay. And I also sent up, it was prepared and I think it's been sent to the court. And I also sent up the order approving my fees as the court visitor. Mr. Easton,
I saw that and I think that's been signed.
Okay, thank you.
All right. So I will go look for that order, and if it's not there, we'll let you know so we can.
So, Your Honor, just to clarify, are we entering the emergency guardianship order today?
Yes.
Okay, thank you.
And I believe I already have that drafted. Ms. Farr will know better than me. Did I send that one to you, the emergency?
I believe I signed off on that one.
Okay.
No, I'm sorry. I signed off on the order from the last hearing.
Okay.
I don't believe I've seen the emergency order yet.
Okay, so I have drafted one. I'll send it to everybody and to Your Honor for review after everybody's had a look at it.
16. All right. November 16th. One of the things that we will need to discuss at that time is what, if any, kind of financial support the parents are going to be required to pay if this continues. So we'll need that information. Ms. Powers.
Thanks, Your Honor. We are involved and will continue to be involved as this moves along in terms of child support.
All right.
Most recently, only one of the children is on TANF benefits with Ms. Harrington. That may provide some relief to the household if the second child is added to the TANF benefit.
And Your Honor, I've already sent out discovery to the parties requesting information about income. So hopefully we'll have something for you next, the next hearing.
All right. And the order is to Ms. Murphy terminating any benefits she might be receiving for the children. That needs to happen today so that that's not an impediment to any benefits there might be for the children. I don't know if she's actually getting any or not. I'm not saying she is, but just in case. I think that covers everything at this point.
Well, Your Honor, what about contact with the parents between now and the 16th? I understand that you've ordered the hair follicle test and the clients are in the process of obtaining that.
Yeah, if and when I've got those results, please bring the matter back on to discuss contact.
So we can bring a motion in the end.
Yes, sir.
Okay.
But those results would be a predicate to that.
In the meantime, are they going to have phone contact or anything with the children?
Let's wait until we get those results.
All right. Thank you, Your Honor.
I think that.